equity powers of the courts came from the church in the UK. And generally the church considered that if the plaintiff were a sinner, they can't claim equity. So if they have unclean hands, they've acted unfairly, with fraud or deceit as to the controversy and issue, then they are unable to ask the court for equitable relief. This is a defense against claims in equity, unclean hands, and it has to be focused on the actions of the plaintiff as to the matter in which it's asking the court for relief. One defense to an equity claim is laches, sleeping on your rights. If the plaintiff knew or should have known of the damage, there was a delay, the delay was unreasonable, and we can look to the statute of limitations to see if the delay could be presumed to be reasonable or not, then the defendant may claim they suffered prejudice as a result of the delay. Perhaps evidence has been lost, witnesses are no longer available, there could be economic losses that have resulted, so the defendant claims the delay has prejudiced their case, and laches can bar claims by the plaintiff. There is an exception for willful copyright piracy where delay does not create a laches defense. Estoppel is another equity defense. Essentially, the defendant is claiming that the plaintiff has changed their position, and this change in position has acted to the detriment of the defendant. It requires three components: an admission, statement or act that is inconsistent with the claim that's later asserted, so evidence that the plaintiff has basically flip-flopped their position. Secondly, you need to show that the defendant relied on this information and that reliance was reasonable under the circumstances. And thirdly, we need to show that there was injury to the defendant and their case from this change in position. So estoppel is a defense at equity. It's not a defense at law, except in some California malpractice cases.